And we're live.
Okay. Well, good evening, everybody. I'm Paul Gullickson, Communications Manager for the County of Sonoma, and we'd like to welcome you to Sonoma County's webinar, which is focused on landlord obligations under the recently enacted Tenant Protection Ordinance here in the county. Before I begin, I would like to introduce our interpreter, Daniela, for a brief word for our Spanish-speaking audience. Daniela?
Thank you, Paul. Bienvenidos a este seminario web. Para facilitar la comunicación, hemos habilitado la función de interpretación de Zoom. Si prefiere escuchar esta sesión en español, siga estos pasos. Ubique los tres puntitos o el icono del globo terráqueo de interpretación que se encuentra en la parte inferior de su ventana de Zoom. Haga clic en este botón o los tres puntitos y seleccione español como su idioma. Si desea escuchar solo el idioma interpretado sin el audio original, puede seleccionar la opción silenciar audio original. Back to you, Paul.
Thank you, Daniela. We appreciate you being here. On September 17th of this year, the Sonoma County Board of Supervisors adopted an ordinance that provides new rights to tenants and new obligations to landlords in the unincorporated areas of the county. The ordinance requires landlords to submit certain information to the county when a landlord evicts a tenant so that the county can track the number of evictions. This information will be entered into a new web portal on the county's website, and we'll be demonstrating that tonight. It also requires dissemination of tenant rights information in English and Spanish, along with any demand to vacate premises or begin eviction proceedings. The new county tenant protections are in addition to the rights already covered under the California Tenant Protection Act, which is a state law passed in 2019. Oh, excuse us, we are having technical difficulties. The live stream froze and may have to start over. Do you want me to start over the script? Okay. Okay, Daniela, we may need you to do the intro again, okay?
No problem.
Good evening, everybody. I'm Paul Gullickson, Communications Manager for the County of Sonoma, and we want to welcome you to the county's webinar focused on landlord obligations under the recently enacted Tenant Protection Ordinance. Before we begin, I would like to introduce our interpreter, Daniela, for a brief word for our Spanish-speaking audience. Daniela?
Thank you, Paul. Bienvenidos a este seminario web. Para facilitar la comunicación, hemos habilitado la función de interpretación de Zoom. Si prefiere escuchar esta sesión en español, siga estos pasos. Ubique los tres puntitos o el icono del globo terráqueo de interpretación que se encuentra en la parte inferior de su ventana de Zoom. Haga clic en ese botón o los tres puntitos y seleccione español como su idioma. Si desea escuchar solo el idioma interpretado sin el audio original, puede seleccionar la opción silenciar audio original. Gracias. Back to you, Paul.
Thank you, Daniela. We appreciate you being here. On September 17th of this year, the Sonoma County Board of Supervisors adopted an ordinance that provides new rights to tenants and new obligations to landlords in the unincorporated area. The ordinance requires landlords to submit certain information to the county when a landlord evicts a tenant so that the county can track the number of evictions that are occurring. This information will be entered into a new web portal on the county's website and which we will be demonstrating tonight. It also requires the ordinance also requires dissemination of tenant rights information in English and Spanish, along with any demand to vacate premises or to begin eviction proceedings. The new county tenant protections are in addition to the rights already covered under the California Tenant Protection Act, which is a state law passed in 2019 that limits rent increases and requires landlords of many types of rental units to have a just cause to evict a tenant who has lived in a property longer than 1 year. Just cause evictions are allowed for such things as non-payment of rent, lease violations, or criminal activity. Under the new county rules, tenants are now protected by just cause requirements as soon as they begin renting, not after a year. They're also eliminating the 1 year waiting period under the state law. State exemptions for subsidized housing from just cause protections are also removed in the county's ordinance. Last month, we held a webinar focused on the tenant protections, which you can watch on the county's Facebook and YouTube pages. Tonight, we want to focus on the new landlord obligations and provide an opportunity to field questions about the new rules. If you have a question, please enter it in the Q&A box in the Zoom and what you're watching. Or if you're watching us on Facebook, where this is being streamed live, we encourage you to leave your questions in the comment area, and we will pick that up and pose that to our panelists. You can also email questions to publicaffairs@sonoma-county.org. That's publicaffairs, one word, at sonoma-county.org. We do want to note we cannot give legal advice on specific situations, but we will do our best to answer general questions. Our panelists for the evening include Elizabeth Coleman, Deputy County Counsel here in the Sonoma County Council's office, as well as Greg Williams to go over the new web portal. So I would now like to turn it over to Elizabeth Coleman to give us an overview of the new county ordinance. Elizabeth?
Thank you, Paul. I'm going to go ahead and share my screen to go through a PowerPoint. I will not be able to be checking questions in the queue while I'm talking, but there will be plenty of time to ask questions after I get through this. It is fairly short, so bear with me for one moment while I pull up the PowerPoint. Okay. So as Paul mentioned, the Board of Supervisors adopted augmented protections for tenants in Sonoma County in September of this year. Please note that the residential tenancy protections under normal circumstances in the county will only be applying in unincorporated areas of Sonoma County. Within the incorporated portions, which you can see on this map, you would be subject to municipal law on the matters of landlord tenant as well as state law, but the ordinance does not directly impact tenants who are within city limits of any of the incorporated areas of Sonoma County. The exception to that is with respect to potential emergency protections, which I will talk about shortly. So here's just a map to give you a sense, and you can go to the URL listed here to look up a particular parcel if you are uncertain whether that parcel is within city limits of one of the municipalities within Sonoma County. So during the height of the COVID-19 pandemic, the County of Sonoma passed emergency protections, first to protect tenants from evictions related to non-payment of rent. State law was then passed, which modified those rules. State law created the possibility for counties to augment just cause protections during the COVID-19 pandemic, pursuant to state law, which the county did elect to do. There was a fairly significant shift in unlawful detainer filings. That's the formal term for an eviction filing, they're unlawful detainer. There was a fairly significant shift during the height of the pandemic and the county's protections. And coming out of those changes, the Board of Supervisors engaged in substantive discussions about whether to augment protections for tenants related to just cause outside of the emergency context. So the ordinance that we're talking about this evening came out of those discussions of the Board of Supervisors. So the ordinance passed by the county is an augmentation of state law. The state of California passed the Tenant Protections Act at the state level in 2019, which went into effect at the beginning of 2020, and it applied certain requirements prior to and substantive limitations on the situations in which a tenant could be evicted. So under state law, in the general case, a tenant's protection from an eviction that didn't rise to the level of just cause didn't apply until 1 year after the tenancy started. So assuming it was a covered type of tenancy, they had to be in place for a year, although in certain circumstances, that could be up to 24 months if folks that lived in the house moved into the residence at different times. The state ordinance breaks down the allowable causes for eviction into two categories. One are at fault, one are no fault causes. So there can be no fault, and we'll talk more about the specifics, but no fault just cause evictions are where a landlord does have sufficient cause, even if a tenant has done nothing wrong. And these are situations like removing a property from the rental market. Whereas other types of evictions have to are based on a cause. So for cause evictions fall into the category of things like lease violations by the tenant, failure to pay rent, failure to sign a new lease after the termination of the pre-existing lease on similar terms. There are fairly significant exemptions under state law in terms of which properties and types of tenancies are covered by these just cause limitations. So while the state law does protect a large number of tenants, there are a large number of exceptions. One of the big exceptions is single family homes. A tenant who is renting a single family home that is not owned by a corporation or a real estate investment trust, those tenancies are exempt from just cause limitations under the state law. And just to preview that exemption has not been changed in Sonoma County by the Sonoma County Ordinance. State law also exempts, this says subsidized housing, but it should say income restricted housing. So properties that by the nature of the property, there are generally deed restrictions that prevent a landlord from renting those at market rate and requires a certain less than market rate level for a certain number of years. Those types of tenancies were exempted under state law from just cause protections. And housing that is less than 15 years old is exempted under the state protections as well. So as new housing stock comes into the market, there is no just cause limitation for that first 15-year period, presumably with the thought that it will protect the investment in new housing stock by reducing the restrictions on landlords. So this next slide compares what state law looked like prior to the passage of the county protections and what is changed in the county ordinance. Under state law, as I mentioned, a tenant needs to be in the property for 1 year before the just cause limitations apply. Sonoma County, again, within the unincorporated areas only, the protections now will apply on day 1 of an applicable tenancy. So they are defined in such a manner that a tenancy that is intended to be short-term does not trigger these limits. It still has to be a real, permanent type tenancy to qualify. But assuming it is one of those types of tenancies, then the protections begin immediately on occupancy. State law requires that where a property and a tenancy is covered by just cause protections and the basis for termination is a no fault termination, a landlord is required to provide 1 month of rent, either as credit or as payment to a tenant in compensation for terminating a tenancy without there being a fault. The county ordinance revises the calculation. So the circumstances are the same. If you would have been required to pay relocation under state law, that won't change. Whether or not this provision is triggered isn't changed by the county ordinance, but the calculation has been revised. So for properties covered by the county ordinance, a relocation payment has to be the greater of 1 month of actual rent or the fair market value of 1 month's rent. And recognizing that can be a fairly amorphous term if not defined, the ordinance includes language defining fair market rent as the rent for a unit with the applicable number of bedrooms in the county as set by the Department of Housing and Urban Development. And the website will have a link to that. So There will not be a question of what your specific unit is worth. It will be a clearly identifiable number based on HUD's determination of the fair market rent. So then the amount that would, need to be paid would be the higher of the actual rent for that unit or the HUD determination of what fair market rent should be. So the exemptions, this determines whether or not a specific tenancy is covered by the tenant protection ordinance. As I mentioned before, single family homes, that exemption has not been changed. So a property that is that type of property that was not covered previously is still not covered in the unincorporated areas. Income restricted housing, the exemption has been removed there in Sonoma County. So this is a little different than saying straight subsidized housing. This does not have to do with whether a tenant has a Section 8 voucher, for example. This is whether the property itself has an income restriction on it. So if the landlord is an entity that has built out a property in a manner that requires it to keep certain units below market value for a certain period of time, those tenancies, those below market tenancies, are now protected by the just cause ordinance. They're incorporated into the otherwise applicable state law protections. And the exemption for housing that is less than 15 years old has also not been changed. So in terms of the sort of first pass looking at whether or not a property is covered, when you make the change from state law to the county ordinance, the only change in terms of what types of tenancies are triggered are just the income restriction revision. Any other type of property that was exempted before is still exempted. Then an additional change made by the county protections is to, under the state law, there's no systematic tracking of eviction notices. So the county ordinance has changed that. So now all terminations of tenancies in the unincorporated area, even if they're not covered by the just cause protections, landlords are supposed to now, within 3 days of issuing that notice, go to the county website and fill out the form to let the county know that the eviction has occurred and provide certain data. And we'll talk through that when we look at the form in a couple of minutes. So that applies whether or not just cause has been applied to the property. And then there are, in terms of the information that then needs to be passed out to the tenants on the just cause protected properties, the county is going to be requiring certain information to be shared with those tenants. So if you have a property that you determine is not covered by the just cause protections, the only new obligation will be to go to the county's website and let us know that the eviction is happening and describe some general categories of information for the county so we can start to track the housing stock and evictions happening in the county. Finally, prior to the passage of the ordinance, there were no emergency specific protections. When the COVID-19 crisis happened and folks were falling behind on their rent, the Board of Supervisors adopted protective measures specifically for that emergency. But in an attempt to be better prepared for the next emergency that might impact housing stock, the board included in the ordinance language that prepositions emergency protections that can be activated by the Board of Supervisors if they affirmatively choose to do so. So this does not mean that every time there's a declared state of emergency for any purpose that there will necessarily be eviction protections, but it does mean that when the board reviews an emergency, if it's making an emergency declaration, it can affirmatively find that the emergency protections should be triggered, at which point more robust protections go into place. This is the only portion of the ordinance that will impact landlords both in and out of incorporated areas. And that's because the county has general authority under the Emergency Services Act to take necessary actions in declared emergencies. So if there's another countywide emergency or emergency that impacts both incorporated and unincorporated areas, the board may activate emergency protections where the circumstances require that cover properties that are within incorporated areas. But that will be specifically known at the time of the emergency, because that would be included in the declaration. So in terms of, just to back up to this slide, I talked a little bit about the tracking of eviction notices and information going out to tenants. So the next couple slides, this information will all be on the website, but this is to describe to you what those types of information are and how they need to be both put out to the community and reported to the county. So the ordinance requires that landlords, when issuing a notice of an intent to terminate a tenancy, provide certain information. There needs to be a statement that information regarding the applicable law is available at the portal. There needs to be a statement that if they want legal advice, they should consult with an attorney. And then it needs to include the statement listed at number 3, letting the tenants know that their tenancy is protected. And so this is only applicable to tenancies that are covered by the just cause protections. They must also be informed as to the date on which they're required to vacate, and then printed copies of the documents that we are identifying as required tenant notices are going to have to be distributed as well. So these 5 points, other than the one sentence that says this notice must be included, these are just statements of the kinds of information that the landlord needs to provide. We have put together a form, and on the slides it got broken up into a couple different slides, but we're putting together a sample form, which is not a required form, but it has all of those points listed on it. So as a landlord, if you wanted to download that form and fill in the date for the termination, you would know that that form that we've determined does meet those criteria. So that form, has this statement here: your tenancy is being terminated, please note, etc. This will be listed on the form. I'm going to back up since this is broken up into 2 slides. This is actually the first page of the form that does affirmatively need to be provided to all of the tenants at the time of termination if they're covered by just cause. So I apologize that this is broken into 2 slides, but it states at the top that it's the notices being provided, lets folks know that there are a limited number of reasons for a proper just cause termination, and it lists those reasons in reasonably plain English. Both the at fault and the no fault causes. And I'm not going to talk through all of them, but they're all listed here, and we can certainly take questions. And then provides them with information about where they can go to get additional information. So it lists the relevant statutory sections. It lists where they can go that the state of California has provided formal guidance on the issue, and then lists a couple of legal resources that tenants can avail themselves of if they would like to seek out legal help. So it's really just to let them know, this is what's going on and this is where you can go if you need help. Okay. And then this next page are additional statements that come onto that same form, continuing to describe the tenant's rights. And that is the last slide. So I know that's a lot. I know that's a lot of information packed into a small amount of space. I think the most important things to come away from this with are, if you have a property that was not covered by just cause limitations by the state law going into the county changes, the properties will only come under coverage if they are income restricted properties. So if you have already had the determination made that it is not a just cause tenancy in general, that won't be changed in other situations. I'm pausing because I noted that there was not a slide included in there for the substantive changes in terms of the proper bases for just cause evictions. So in addition to starting the protections earlier on the commencement of the covered lease, the protections also revise the standard for terminating a lease for the just cause of non-payment of rent. And so this is a fairly important one. Under state law, non-payment of rent will is listed as a proper basis for termination. And it still is under the county's ordinance, but the protections for tenants are augmented so that a tenant may not have their tenancy terminated for not exceeds 30 days worth of unpaid rent, which is to say, if a tenant owes less than 1 month's worth of rent, they are not terminable for that period of time that they are behind. And Paul, I just got a notification that my internet is unstable. Can you
It's
hear
a
me?
little wobbly. If you could just state that
Okay.
last, it's been pretty clear for the last 10 minutes, 15 minutes. So if you could just
Okay.
restate that last part about
Okay.
the 30 days and the augmented requirement.
Okay. So the county ordinance, while it is true that only tenancies on income restricted properties, that's the only change to which types of tenancies are covered. In terms of the level of protection for tenancies being terminated for just cause, under state law, a non-payment of rent is without restriction a just cause and at-fault basis for termination. Under the county code, there is a new restriction on that the tenants can avail themselves of no more than 2 times per calendar year. If a tenant is behind by less than 30 days of rent, that is not itself a for-cause basis of eviction, which means that in the course of a calendar year, if a tenant falls behind in their rent no more than 2 times and for no more than 1 month, they are not evictable on the basis of that non-payment. If a non-payment goes on to be more than 30 days of non-payment, they become evictable for that event. Or if it happens more than 2 times in a calendar year, that is also a proper basis for a at-fault just cause eviction.
Okay. Well, that's helpful. I mean, the bottom line is non-payment of rent is still a just cause eviction, cause for just cause of eviction. It's just it's more than 1 month in that case. So,
Correct.
okay. Well, that's great. Elizabeth, thank you very much. I know we're going to come back to you for some more questions, but let's go to Greg Williams from the county's Information Systems Department to give us an overview of the new web portal for landlords and how to use that. Greg?
Yeah, thanks, Paul. Let me go ahead and share my screen here. Can everybody see it?
Looks good. Looks good, Greg.
Okay, so here's the thing. When ISD creates an e-form, we basically have 2 major requirements. The first one is that we want to create an environment that we capture as much information that the department requires from the individual. And on the other side, we want to make an environment for the individual when they're actually interfacing with the e-form that is a pleasant experience, that they feel comfortable about giving as much information as possible.
For rainy weather with a high of 56 degrees.
And Alexa just started to cut in here. Sorry. So let's take a look at this e-form. We're going to put in the first information, the first name, last name. I have my email already in here. I can put in a street name and a zip code. These are required information before we go into the other areas. And then let's look at some of the drop downs here. This one is enter the type of resident for which the notice terminating tenancy is issued. And it's a drop down. And we have several things that we can select from. If for some reason these drop downs don't have the information, you'll see this on the right-hand side. We can actually type some other stuff in here. Let's look at the total number of bedrooms. We'll put 2. Bathrooms, we'll say 2. We're talking about enter the length of the resident of the rental market. We have less from 1 year all the way down to more than 10 years. Let's do 2 to 4. enter the length of the longest occupying tenant. Again, we less than 1 year, all the way down to more than 10. We'll say 2 to 4. Enter the number of adult tenants. We can say 2. Minors, we can say 4. And for seniors, let's say 2. And then we have some open text here. This one is enter the monthly rent of residence at the time of notice of termination tenancy was issued. If separate utility or surcharge, the surcharge to the tenant, please include the amounts in whole numbers so they can put that in here. Number 12 is that for at fault terminations, enter the reason for terminating the tenancy. And this is a drop down, and you can see that we have a bunch of them here. Just pick that one. Number 13, for no fault terminations, enter the reason for notice of termination tenancy. And again.
And Greg, if I can just jump in and provide a little context for the form. So the intention here is to gather general information about the housing stock in Sonoma County and what the circumstances are around the termination of tenancies, and to get a picture of what types of properties are coming on and off of the rental market. So you'll note that the specific address is not required for the property. It's just the street and block number so that we know generally where the properties are. Then, you know, the number of years that folks have been living there and how long they've been on the market are important information. The bedrooms and bathrooms are fairly self-explanatory. Regarding the numbers of the residents, it says if known. So to the extent you do know who's living and the ages, you know, we're trying to get some general demographic information about the folks who are losing housing so we can help understand what the trends are in the county. And then on these 3 questions, 11, 12, and 13, that talk about the basis for termination, these are intended to be mutually exclusive. So if you have a tenancy that is covered by just cause protection, if it is a no fault termination, you would pick the appropriate no fault option. If it is a for cause termination, you would instead pick the basis. Those are closed lists so that you can only pick from the statutorily allowed reasons for terminating. And then 13 is intended if it's here. If it's 14 is intended if it's not a just cause situation, if it's a tenancy that's not covered by these protections, because not all of them will be, you can enter the reason, and it does not need to come from those drop downs because it doesn't need to be one of the statutorily allowed bases for termination. So that's the basic structure of how the form has been put together. And Greg, thank you so much for putting it together.
Thank you. And then the last one here for number 15 is, do you anticipate reletting the residents within 180 days after the notice of termination? And of course, it's just a drop down that says yes, no, or uncertain. And then from there, after they finish that, they will hit the submit button, and then it goes to a repository. And Paul, I'm going to send it back to you.
Okay, thank you, Greg. I appreciate it. We actually have a couple. Let me throw one quick question that we had here. Na asks, on the form, is the address of the property or the address for contacting the landlord?
That is the address for the property.
Okay.
So the landlord contact information is just that there's an email and name there so that we can confirm that it's been submitted. But
okay,
the street name is just to say where the property is.
Okay. All right. Thank you. Well, as you can see, we're now going to take questions from our audience. As a reminder, if you have a question, please enter it in the Q&A box at the bottom of your Zoom screen, Or if you are watching on Facebook, you're free to leave your question in the comments section, and we have staff on hand ready to read those to our panelists. You can also email questions to publicaffairs, one word, at sonoma-county.org. And just as a reminder, we cannot give legal advice on specific situations, but we will do our best to answer general questions you may have about the ordinance. So let's start. We've actually answered a number of questions in the Q&A box, but just for our listeners' sake, Greg asks, is this being recorded? Yes, it's being recorded via Facebook and YouTube. They'll be available after this session. We'll also look for other opportunities to post this recording. Tiffany asked, do these new restrictions for landlords only apply to unincorporated areas? Yes, it's only unincorporated areas, right, Elizabeth? For the most part, correct?
Yes, with the exception of under the emergency portion of the ordinance, if invoked, yes, these only apply to unincorporated areas other than that.
Thank you for making that stipulation. Here's a question. How do I know if my property is in the unincorporated portion of the county? Lois has provided a link to a website on our county page where people can actually check their website. It is parcelsearch.permits.sonoma.org. You could probably just Google parcel search Sonoma County or permit Sonoma, and they'll take you to that link. Any other suggestions of how people can find out whether they're in unincorporated areas? That's probably the best suggestion, I guess.
I'll look to Lois for that. I don't have an answer.
Okay.
When they go to that parcel search, they'll get their property report. That's the only way that I'm aware of at this point.
That's a good idea. Yeah. Okay. Who will have access to the data? So the answer is, well, Lois, do you want to answer that?
Yes, when a landlord enters that information into the portal, that will be a public record. It's partly why we just have the street name and the zip code to try to protect some information. But yes, it will be a public record.
Okay. Elizabeth, this could be a clarification. Keith asks for a clarification whether condominiums are treated the same as single family residences.
Yes, so technically the way the statutory language reads is that separately alienable interests are exempt, and separately alienable means you can sell them separate from another piece of property. So condos do fall into that category. Those are single family occupancies. We did include condos in the drop-down menu for information being reported when a termination occurs, but that's for purposes of understanding the housing stock and not for application of the ordinance.
Okay. Okay. Thank you. Tiffany asked, is there a need to provide a Spanish form if they, I assume, tenants are English speakers?
That's a good, well, the ordinance is written so that each tenant has to be provided the form in both English and Spanish. I ran through the content of it. We do not yet have the translated version of that, but it'll be a one-pager in English and probably a slightly longer but similar document that's identical in Spanish.
I'm sorry, Elizabeth, Paul.
Yes, Greg.
So if I can share real quick, we have it in Spanish right now.
Okay.
Greg, if you wanted to share screen to just show folks what that looks like, I don't have.
Okay.
And this document will be linked at the website for download.
Okay, so that's English. If I select Spanish, it goes to Spanish.
Okay.
Okay, and so that's for the fillable form. I believe the question was about the information that needs to be pushed out to tenants specifically, and that is a form that will be in both English and Spanish, regardless of the spoken language of that specific tenant. It's just a blanket requirement that they receive it in both languages.
Okay, thank you. Sorry about that.
Okay. No, that's perfect. Thank you. So Na asks, so does the lease with the tenant need to include additional language for those affected properties?
Nothing in the county ordinance changes what the landlords need to have in their leases at
Okay.
the commencement. There are certain impacts on the state law side that change based on what is in the written lease. So if you have questions about what language in a lease would best protect your interest, you should consider talking to an attorney about that. But from the perspective of the county ordinance, there are no new requirements to be put into a lease.
Great. Thank you for clarifying that. Here's another clarification. Tiffany asks if the tenant, I guess, are not protected from the Tenant Protection Act, but it has been less than 1 month unpaid rent, you cannot evict? Is that right?
So the only tenants who can avail themselves of the limitation on termination for non-payment of rent are tenants who are covered by the just cause protections. So if you have a single family residence that you are renting out, the limitation would not apply because they are not entitled to those just cause protections. So if you determine a property is covered by the just cause limitations, then the limit that you cannot evict unless they are more than 30 days behind in rent will apply.
Okay.
Does that make sense, Paul?
It does to me. I thank you
Okay.
for clarifying. Hopefully Tiffany feels the same. Clayton asks this question, and again, this is confusing, so I appreciate the question. So does the tenant need to be late 60 days before notice of unlawful detainer? And what does 2 30-day lates in 1 year mean?
Yeah, good question.
So the way that the ordinance is written is actually, it's about the amount of money that is owed as opposed to the number of days behind. So the failure to pay rent, once it has exceeded 1 month's rent, becomes an evictable offense. So and so generally that would occur after 30 days. And that limitation can only be used twice a year. So if you say a person is behind exactly 1 month's rent and they pay it on the last day of the month, if that happens twice in a year, you can't evict them for that. If they go past 30 days more than once, within the calendar year, if you get past 2 times, then that would be a sufficient cause for eviction. So it doesn't have to go 60 days in a row for it to be an eviction.
Okay, thank you. This individual asked to be remain anonymous, but he or she asks, what are the penalties or consequences for landlords who fail to submit this form on the portal?
It is a violation of the county code, which is all violations of county code are technically misdemeanors. So that would be, as to that particular aspect of it, it would be enforceable as a misdemeanor in the same way that any other county violation would be. With respect to the rest of the ordinance, aspects that have to do with whether or not a landlord can initiate and complete an unlawful detainer provision, those will be enforced by the courts. So if a landlord improperly terminates a tenancy, that's something that would be addressable by the court when a landlord is trying to evict a tenant.
Yeah. Okay, this is a question from one of our Spanish-speaking viewers. Here she asks, I am a tenant. The owner of the house wants to sell the house. I have lived here for 11 years. We do not have a lease. I have never defaulted on the rent. What just cause could apply in my case? It sounds like it's a single family residence, the house.
I'm gonna see, since this is a tenant, if Patrick wants to jump in. But as a general case, single-family residences are not covered. That is
Right.
not always the case, depending on the ownership. When just cause protections do apply, the selling of a property itself is not listed as a proper basis. If a property comes all the way off the market, that counts, but sale by itself does not always constitute just cause. But I can't advise you on your specific.
Okay. Yeah, that's understandable. Okay, here's a question from Kate. Have you mailed notice to all, has the county mailed notice to all unincorporated owners to notify them of these new requirements?
Lois, you can jump in if there's a response from CAO, but the noticing provisions that I'm aware of are related to generally applicable passage of ordinance, which are publication and public hearing requirements, which the county did in the course of September. And then there was a subsequent publication of a summary of the ordinance made in the Press Democrat.
Yeah.
Yes, I don't have anything to add.
Yeah, and we're also it's the reason we're doing these webinars is to get the word out about these new protections and these changes. So okay, can my landlord evict me without cause and simply pay me the 1 month rent penalty, or do I get to keep living there also? Any other things preventing my landlord from evicting me without cause?
So
Yeah,
again, I can't, I
yeah.
can't answer questions about a person's specific, whether or not they are or are not in a terminable situation. I'll just clarify that the relocation benefit is something that is supposed to be paid by a landlord when just cause limitations do apply and the basis for the eviction is a non-at fault. So that's a situation where the landlord's family wants to occupy the property or they're going to take it off the rental market entirely. Those, in those situations, a landlord can terminate even if it's covered by just cause. It doesn't have to be because there's a fault by the tenant, but in those you did nothing wrong situations where you do have the protections, then you're entitled to the payment. And it does not impact whether a person can or cannot stay on the property. That would really be a question for the court.
Okay. This is a technical question. Will the county be uploading approved forms for 3-day notices to pay rent or quit and or 30-day notices to pay or quit for properties subject to AB 1482?
No, the county is not making any revision to the noticing requirements. Those are all set by state law. So any currently existing court-approved forms will still apply. The county's recommended form will solely be with respect to the additional noticing that we are requiring landlords to send to tenants who are covered by the just cause protections from the augmentation under the ordinance.
Yeah. And there was a subsequent question about whether a notice that a property is subject to these protections, whether it'll be required in the rental agreement, but you've already indicated no changes in the rental agreement are required.
Yeah, and I will note that the state law does at certain points change. There are implications for landlords' obligations that flow from what is or is not listed in the lease, but that's not a matter of counties, that's state ordinance, and we can't really get into that.
Okay, you garbled on us a little bit there, Liz. So that
State
last
law,
sentence. Okay.
okay, state law does matter what is in the lease for purposes of state law. The
Okay.
county is not changing any aspect of that, so we are not advising on that, and no new impacts will flow from the language of your lease from the passage of this ordinance. So I'm being a little I just want to make it clear that it can matter what's in the lease. It's just not being changed by this ordinance.
Fair enough. Okay. We have several more here from Rose. Do landlords that have a single family rental home, which are exempt, do they still need to tell the county of an eviction?
Yes, if you are in the unincorporated area, you do need to fill out the form, but that is the only new obligation under the new ordinance.
Okay, that's good to know. Dustin asks, how long do tenants have to make rent payment or payments after they've missed a payment? Say they missed January's rent, do they owe that in February along with February's, or does the non-payment roll forward?
The ordinance does not deal with the timing of the payment, which I know seems a little odd since you think about non-payment in terms of a month, the date it's supposed to happen. But the ordinance is very specifically constructed to be based on how much rent they are in arrears and not how long they are in arrears. State law still covers on that, which is still 3-day notices to pay or quit, followed by the procedure set out in state law. But the trigger number is changed to being greater than 30 days worth of rent 2 times per year.
Okay. Thank you. Na asks, so are Section 8 rentals of a single family dwellings exempt?
If they were exempt previously, which they most likely are, if it is a individually owned property, not owned by a corporation, those will stay exempt. The acceptance of Section 8 voucher does not qualify a property as itself being income restricted. And income restriction is the language that's in the ordinance. So just because you accept Section 8 does not make a property that was otherwise not covered.
Okay. Okay, Marissa asks, how are you calculating a year? I think this is in conjunction with the missed non-payment. How are you calculating a year? Is it fiscal or general calendar year?
Calendar.
That's pretty straightforward. And Na asks, if my tenant's lease states they have 60 days to pay, is that okay? I guess I'll start with that one.
I can't get into
Yeah.
the impact of the language. So unfortunately I can't answer that question.
Okay. Is the additional notice required by this ordinance only required when an unlawful detainer is filed?
The additional notice is required upon informing a tenant that you are terminating. So it would be required prior to the commencement of unlawful detainer. It's when you tell them that you're terminating the lease, when you give that notification, that's what triggers the informational requirement.
Okay. Okay. I guess Clayton also asks on the form itself, why are we asking the landlord's name and not the tenant's name?
That is so that the county can confirm that a landlord has in fact submitted the information. That provides both you and the county of a record of compliance.
Okay. Okay, and Kate, go back. She asks if there's a way that we could email or share the slide that shows the changes that have occurred from 1482. Is that posted anywhere on the website or the county's site or anything?
We can certainly post the presentation here on the website.
Yeah.
And if that's of interest, I think a copy of the board summary from the adoption where that is laid out more clearly, because these are just, talking notes for this seminar and it's not as inclusive
Yeah.
as the board item that did cover those changes as well.
Yeah. Okay. All right. Well, I think we've covered all the questions that we can. There's some repeat questions, but I want to just thank everybody for their submission of these questions. But we also want to say, as we noted, there in some cases we could not give specific legal advice, but if you have a specific legal question, we want you to feel free to call Legal Aid of Sonoma County's housing team, and the number is 707-843-4432. Again, that number is 707-843-4432, and Legal Aid can help you get the answer that you need. In any event, I want to thank Deputy County Counsel Elizabeth Coleman. Liz, thank you. And Greg Williams from the county's ISD department. Great work. Really good discussion, important information to be shared. And always, we want to remind you that you can find more information about the county's tenant protections at sonomacounty.ca.gov/tenant protections, or just do a keyword search on this county's website, tenant protections. And in any event, thank you all for joining us this evening, and we hope you have a great evening. Good night.